Today, a federal judge issued one of the most devastating rulings that I have read since I started law school. She didn't just throw out a $1 billion settlement involving President Trump. She said the entire lawsuit may have been built on something that, legally speaking, wasn't a real fight at all. This case could become one of the biggest court decisions defining the limits of presidential power during Trump's second term. You know I took notes. Let's talk about it. To understand why this ruling is such a big deal, we have to go back to Trump's first term. A man named Charles Littlejohn was working as an IRS contractor. That means that he wasn't a federal employee. He worked for a private company hired by the IRS. Littlejohn illegally accessed leaked confidential information belonging to Donald Trump, members of his family, and the Trump organization. He later pled guilty and was sentenced to 5 years in federal prison. Fast forward to this January, President Trump, Donald Trump Jr., Eric Trump, and the Trump organization sued the IRS for $10 billion. That is important for later. Mind you, a lawsuit exists because two sides disagree and they ask the court to decide who is right. Without two truly independent sides, you don't really have a lawsuit. So let's stick a pin in it. This case never made it to trial. Instead, in May, the administration announced what it called a settlement. A settlement simply means that both sides agreed to end the lawsuit instead of asking a judge or a jury to decide it. On its face, that sounds normal, but this settlement wasn't. It created something called the Anti-Weaponization Fund. That fund is worth $1,776,000,000, which is a number that many believe was intentionally chosen to reference the year 1776. According to the agreement, that money would compensate people who claimed they had been unfairly targeted by the federal government. That included some people connected to January 6th and the classified documents investigation. Then something happened the very next day. Acting Attorney General Todd Blanche signed another order. Remember, acting means that he's temporarily serving as Attorney General while awaiting Senate confirmation. According to the judge, that order protected President Trump, members of his family, and their businesses from future IRS audits and investigations. An audit, if you have never had one, is the IRS's official review of your tax records to make sure everything was reported correctly. Almost immediately, Republicans and Democrats alike began asking questions. Why was taxpayer money involved? Who approved this? Could the government even do this? And within weeks, the administration quietly abandoned the fund. And now we know why. Judge Kathleen M. Williams spent 56 pages answering those questions. Judges don't just write opinions that long because they enjoy writing. They do it when they want every legal conclusion documented, especially when they know their decision may be closely examined or appealed, studied, in my case. Her biggest conclusion wasn't actually about the money. She said that there was never a real legal dispute. Think about that. The president was suing the federal government, but as president, Donald Trump appoints the Treasury Secretary. The Treasury Department oversees the IRS. He also appoints the people leading the Justice Department, the very lawyers responsible for defending the government in court. Then Judge Williams pointed out one of Trump's own executive orders. An executive order is a written directive telling executive branch agencies how to operate. According to the judge, that order required Justice Department lawyers to follow the president's legal positions. So ask yourself, if the president controls the agencies being sued, controls the lawyers defending those agencies, then who exactly is arguing against him? Nobody. Nobody was arguing against him. For 109 days, this lawsuit was pending. Not a single time did a government lawyer file a response defending the United States. Not once. Judge Williams compared that to another lawsuit over the exact same tax leak. That case involved years of litigation before reaching a modest settlement. This one, no litigation, no adversarial fight, no real defense. She even criticized the amount itself. The $1,776,000,000 figure, she wrote, looked more like branding than an actual calculation of damages. In other words, the judge believed that the number was chosen because of its symbolism, not because anyone had proven the amount represented actual harm. Judge Williams wasn't saying the tax leak never happened, because it did. She wasn't saying President Trump couldn't sue. He could. What she was saying is that the courts exist to resolve real disputes between opposing parties. And in her view, there were no truly opposing parties here. Instead, she found that the lawsuit was used to give legal legitimacy to an agreement that likely would have never survived normal judicial review. That's why she took the extraordinary step of prohibiting the parties from referring to this agreement as a settlement in future proceedings. Don't even play on her. If you think that this is the biggest part of the opinion, it's not. After Judge Williams finished dismantling this agreement, she turned her attention to the lawyers who built it. What she did next could affect the careers of some of the most powerful attorneys in federal government. That's going to be in part two.